John Hiatt is the General Counsel for the AFL-CIO. He was appointed to that position on November 1st of 1995. Mr. Hiatt previously served for 8 years as General Counsel for the Service Employees International Union, where he directed that union's legal department. Before joining SEIU, he was a partner in a labor law firm in Boston. Mr. Hiatt graduated from Harvard College and the Bolt Hall School of Law at the University of California, Berkeley. Hiatt, welcome to the committee.
In my written testimony, I tried to show why the Bush administration's stripping of worker protections over the past several years with its latest decisions in September doesn't simply reflect the proverbial swing of the pendulum that at times in the past has characterized NLRB case law from one administration to the next. So I'd like to use my time now to offer just a few examples of what the impact of these cases is likely to be on the ground among the workers. Let me start with the Dana case and the board's rewriting of the rules on voluntary recognition, which, as you know, has been on the books since the law was enacted and has until now been viewed by the board and the courts as a perfectly acceptable alternative to NLRB certification. Indeed, in 2003, Chairman Batista himself stated in a case called Terracon that Senator Kennedy referred to that its holding in that case was consistent with the board's established objective of promoting voluntary recognition in order to effectuate the Act's purpose of promoting collective bargaining. Because the board's election procedures have become so confrontational, so easily manipulated by any well-advised employer, and so delay-ridden, more and more unions and workers have indeed been avoiding the board entirely and seeking voluntary recognition. This incidentally explains a good deal about Chairman Batista's selective use of statistics. Little wonder that the board is closer to meeting its quotas on deciding cases when you consider the enormous reduction in both unfair labor practice cases and election cases that are brought to the board anymore. In any event, recognizing this trend and noting that workers were having increased success with the alternative means of achieving unionization, this board is now determined to make it as hard as possible to obtain union recognition, even where a union, an employer, and a majority of the workers are all in agreement. So much for the avowed philosophy of non-governmental interference and deferral to private dispute resolution. Add to this the shameless hypocrisy when majority petitions or cards are described by the board in the Dana case as inherently unreliable, as susceptible to group pressure, as admittedly inferior to the election process when workers are trying to bring in a union, but then on the very same day are told by this same agency in the Wurtland case that none of these are concerns when the question is getting rid of their union, that the signature method there constitutes, quote, objective proof of the employee's withdrawal of support for the union, and that an NLRB election is not necessary. And how do we explain why the government will now start posting notices informing a minority of the workforce of their rights to seek to undo the voluntary recognition and how to go about it without any corresponding posting of affirmative rights to join or form unions under the Act? Mr. Cohen may call this quibbling. I suggest this will have a major impact. As a second example, consider the area of remedies. It's already hard enough to give assurances to workers that if they stick their necks out in a union campaign and get fired for it, they'll be reinstated with back pay. Reinstatement typically comes 2 to 3 years later, and with an average, as Senator Kennedy said, of about $3,600 in back pay. But now, after the board's Grosvenor Resorts and St. George Warehouse decisions, even these explanations are put in question. In the former, when workers were unlawfully fired and picketed for 2 weeks in Ms. Ryland's workplace in order to get their jobs back, the board ruled that no back pay should be awarded for those 2 weeks because to do so would be to reward idleness. And in the second case, the board has reversed decades of precedent and said that from now on the burden will be on the worker, that is the discrimination victim, to prove adequate mitigation in seeking alternative employment in order to collect back pay. Until now, the wrongdoer employer had the burden of showing that those efforts were not sufficient. Already 1 in 4 employers faced with union campaigns fire lead workers for the chilling effect that it has on other workers contemplating getting involved. What more incentive does the average employer now need to see this anti-union tactic as a minuscule cost of doing business, one that comes with the Bush board's seal of approval? Finally, a third example of real-world impact will be on workers' rights to bargain collectively and strike when necessary. In Jones Plastic, the board has handed employers a roadmap to deny employment to returning strikers. In the past, it was well settled that to be considered permanent replacements who would be allowed to continue working in place of strikers after a strike had ended, there would have to be a mutual understanding ahead of time that the replacements were in fact permanent. With this new decision, the board has now declared that even if an at-will employee signs an agreement acknowledging that he or she can be terminated at any time with or without cause that can still be considered permanent for purposes of denying reinstatement to returning strikers. Given Chairman Batista's assertion that the Act's central purpose no longer calls for the Board to facilitate employees' opportunity to organize unions in order to promote collective bargaining, notwithstanding pronouncements directly to the contrary by the U.S. Supreme Court in the American Hospital Association versus NLRB case in 1991 and by numerous courts of appeals as well, it is sadly not surprising that this Board has moved the law in a direction so hostile to worker rights. It's time, however, for Congress to step in and correct the course. Thank you very much.